Yeah. Bring your stuff.
One second.
Go.
Cool.
Yes. Oh, these are like I don't know. We don't know. Yeah, that's the guys.
Yeah. But I'm always for stepping out of decisions. All right. Ni hao, motherfuckers. My name is Lydia, and I'll be your chair in Prop RB of SMU A-LMOST on the topic of crimes and acquisition in right country. Huh?
Me. Oh, okay. You decided already? No.
The way in which the criminal justice system views crimes of acquisition is not one that looks into the assault of dignity of a person. We think that there's an ability for you to lose what you may have, Mr. Speaker, in terms of what your life should have been when you lose that amount of money, which is proportionate to how much a person steals from you. The debate has to operate on a spectrum of us acknowledging that there's a person who will then lose money proportionate to how much that amount of money, which can be a lot, Mr. Speaker, can be used in their further life at the end of the day. And that's how the debate should be about. Let's talk about how punishments are determined within status quo. We think it is very arbitrary and vague in nature based on a collective good in how the courts can decide what is at the end of the day good for you. There is no real measure whatsoever as to how society will then benefit from it, Mr. Speaker, because somehow judges can decide what inherently is good for different victims who have different backgrounds in that certain scenario. For example, Mr. Speaker, different countries have different penal codes with a maximum or minimum penalty which then differs, and they provide you a range in which the courts can then decide whether or not we want to give a person who might have committed the same crime as another person, but because of their background and the defenses they raised in that circumstance, Mr. Speaker, somehow this person can get 5 years in jail while another person can get 3 years in jail. Acknowledging this, Mr. Speaker, proves to you one simple point, that it can be disproportionate in that certain scenario that is inherently a harm. No, thank you. The debate has to operate on a scenario where we also acknowledge that it is about criminal courts, Mr. Speaker, and giving punishments, because we don't think that the civil court does this any better when you only give damages, Mr. Speaker. We think that there is better redress when you talk about punishments, Mr. Speaker, and how you can punish people who have assaulted the dignity of a person who might have lost that amount of money. No, thank you. Why is there a problem in crimes of acquisition, and why are we willing to say that this is different from any other? We think that it is very likely that people who will become targets or victims of victims of these crimes, Mr. Speaker, are most of the time people who have property where it is reasonable for you to make a trade-off, that it is substantial for you to become, to commit that crime at the end of the day. Things such as fraud, Mr. Speaker, or things such as criminal misappropriation of money or criminal breach of trust would then entail a lot of money that comes onto you, Mr. Speaker, because corruption works that way. But also, Mr. Speaker, we think this debate is also an assessment of what the victim's wealth actually is. We think that when the courts learn to assess how much effort was put in by the victims in order to have that scale of property, Mr. Speaker, whilst we understand there are different variables that a wealth of a person can be determined by, things such as inheritance or things such as having a rich family, that's fine. We're also okay with taking into account what this person has to do in order to obtain the amount of wealth in the first place. So the debate is an evaluation on two things. Firstly, why likely we tell you that these people will be targeted, Mr. Speaker, no thank you. But secondly, why we protect the people on all these fronts who are victims of the crime. The concern that will probably come from them is the debate about poor people, Mr. Speaker. Under status quo, no thank you. We think that there's no guarantee whatsoever that there's a legal redress for these poor people that they probably want to talk about at that certain scenario. The case may not seem as viable when you don't have substantial amounts of money to prove that fraud would then even happen in the first place. We have to move on with what the greater part of the portion of the debate would then become. Before I move on to my second issue, sure.
Who would be more punished on your side?
Shit. I'll tell you. I'll tell you my arguments necessarily, right? Okay, so the person who will be punished even more is the person who takes more money from a wealthier man. I can't believe you don't get that from the motion, right? Let's talk about two issues, Mr. Speaker. Firstly, why we think crimes of acquisition should have this policy in place, Mr. Speaker, and secondly, why this would require a more what set of behavior do we want to obtain at the end of the day? So let's talk about the first thing, why crimes of acquisition should implement this policy on three key aspects. Firstly, Mr. Speaker, damages in courts or the proportionality of punishment works in a way where you have to give back redress proportional to how much this person has probably stolen or probably would have stolen from that victim. Notice how important it is to say that there's a reasonable amount of money that would have been, that we can expect this person to be, that money to be stolen from that person, right? So that means that a richer person will probably have a larger pool of money on an aggregate that harms you larger, Mr. Speaker, because the person who commits theft on you would have taken even more from you, right? And that's the position that we're likely to take. That, on a principle, means that the more dangerous, the more property that you steal from a person, that means there's bigger punishment, right? But also, Mr. Speaker, acknowledge this, right? Let's say a company loses $1 million and another company probably loses $1,000. We acknowledge that both of them do suffer an injury, but the magnitude in which a company may lose $1 million as compared to 1,000 means that that $1 million could have been used in order to roll for to get even more money than they would have then had under that side of the house. This should be accounted for as a factor, as opposed to your courts who never look at the victims of a crime, but the background of the perpetrators who have done that crime. Even if this debate is about a teacher, Mr. Speaker, who gets his money stolen due to fraud and cannot use that for his retirement fund, Mr. Speaker, the courts in that circumstance should look into how your lifestyle should have been, should your retirement fund be even larger in that certain scenario. The criminal court doesn't even do this in the first place. That's why we want that, Mr. Speaker. But second aspect, no thank you. The way in which the wealthier is treated within this scenario or status quo is not taken into due to the presumption that the courts may have. It's very easy for people to say that we don't want to give redress to rich people because they have enough capital to fall back on anyway. The fact that you have a prejudice on these people, that richer people don't deserve as much of a redress, is a harm in and of itself. But thirdly, Mr. Speaker, the criminal justice system tries to work on the boundaries of equity in which it's not objective, because they look into the background of what the perpetrator actually is and not entirely the victim. That means there's no focus at all as the victim getting redress for what they may have benefited from should the money had not been stolen, Mr. Speaker, but in fact only want to punish a person even more and not give more redress to the victims that we're talking about. So what is the world in which we envision the debate to be in? One that addresses the dignities that are assaulted by people who may have necessarily stolen more amounts of money from you, should we acknowledge that you might have been richer at the end of the day. criminal justice system doesn't do this in status quo. That's why they should start thinking about the victim and not just the perpetrator.
The PM, I'll be there.
So one principal clarification I would like to make is what is different from status quo on their side. Because on their side, they would like to contend that the more you steal from a person, the more you have to pay back. That's simple, right? Because we think that's the way the justice system works. That the more you steal, the more you take, the more you have to give back in terms of retributive justice. We think that that's clear in status quo. What they weren't necessarily clear about when we asked them in a POI, so who would get redress, is the question of which. For example, if I take $500 from a rich man and a poor man, who do I pay back more to? We think that was a burden they had to defend, that we had to pick either one because that's what we consider wealth, right? That's why we decide the sentence based on wealth. Since they were very, very unclear on that, we're not very sure where to take this. But let me defend what he tried to say. So he started off his speech talking about the justice system and how it's kind of already arbitrary and that judges still decide things on like penal codes as well. Look, we think that their side doesn't change any of that as well, because judges are still equally as biased on their side, because judges are still used to decide mitigating factors that will reduce punishments for perpetrators. Judges are still used to decide the end goal of a crime or like what we should consider guilty or not. We think that those things don't change under their side. We think that they need to tell us why in any way they will mitigate these problems, right? And fundamentally, we also tell you that knowing your penal code is probably your duty as a citizen as well, right? So irrelevant. So, okay, then he moves on to talk about the likelihood of you living a better life if you had that kind of money. We told you, at the end of the day, this principle kind of extends to infinity. This extends to other things like assault as well, and they can't have any kind of exclusive say over what crimes of, over these crimes of acquisition. Why? Because we're talking about the likelihood of a better life. If a poor man gets assaulted on the street and is incapable of paying for medical help, he also lives a worse life, right? So where does your principle stop? Yes, Jay.
When it comes to crimes of acquisition and the penal code, there is no financial redress that is given to the victim. The comparison of the debate is a dignity and honor that is attached to the property that is taken away. Engage in that debate.
Okay, then that is a debate about providing financial redress, not providing financial redress on the basis of the wealth of your victim, which is to mean that your victim's wealth is the sole deciding factor as to how much I should give you or how much I should compensate you. So be clear on that. Essentially, what they try to also tell you that, okay, it's about the magnitude of the money that you steal, right? In the end of the day, they still hurt poor people. Why? Because if you steal $100,000 from a rich man who has the likelihood to offer you that $100,000 to steal in the first place, they are likely to going to get the larger redress. That's a metric by which they would like to consider how much you steal and the magnitude of your crime. We think the poor people are still screwed over because they don't just have that much money for you to take, right? Essentially, they were very, very unclear on what their model was and how it was different from status quo. And here's where I'll tell you my alternative. This is a perversion of justice on their side. We think that this fundamentally deals with a lot of the basic tenets of justice they would like to try and defend, right? What's justice then? We think that retributive justice is not proportional to it's proportional to the intent and other mitigating factors that we consider. For example, the poverty of, say, someone who conducts petty crime and petty theft, right? We think that this is already accounted for within the justice system. However, what it is not proportional to is the wealth of a victim, because we recognize, for example, if you take $500 from anybody, that's probably going to hurt as well. We think that it's a value of the crime in it of itself versus its relative value to the victim that we charge you for. We think that there are primary harms in picking the converse, right? We think that the fundamental idea of law is that it compensates you blind of context. It compensates you blind of what your status in life is. And we tell you, on their side, they are choosing a very arbitrary metric to consider the severity of a crime. Let's talk about wealth acquisition then. What is wealth acquisition and how do we, what are the metrics why we decide? It's like two basic arguments, birth lottery and like personal endeavor and how much you get from your money, right? So let's assume, for example, that a rich person may be compensated more by the basis of their circumstance, that they are poor, and therefore they feel like they should be compensated more than by the law because they otherwise wouldn't have gotten financial redress. Again, we tell you that birth lottery and whatnot is a very bad way to decide how to run your justice system, because people don't pick and choose the circumstances they are born into. The rich man never chose to be rich if his family had a great windfall in his great-grandfather's life, right? Like at the end of the day, wealth acquisition in terms of the birth lottery is a completely arbitrary metric because nobody chooses what their birth lottery essentially is. And because they don't choose this, the law cannot say that the individual's mitigating circumstance is something beyond what they necessarily chose. Versus personal endeavor as well. For example, if we talk about how the rich man has made his own wealth and therefore we can take it from him because and the proportionality, we think that's also kind of ridiculous because you are penalizing the wealth of an individual he accumulated for himself because he somehow is rich, right? Mitra, if you want to become an investment banker, that is your personal endeavor, but nobody should have to penalize you in the law for choosing to live a life that perhaps would give you more access to money. We don't think that that's a metric by which we should judge the legal system. Now, what does this necessarily create? And what is the harm of their side's policy? This creates a dangerous precedent because it abandons the traditional conception of mens rea, the traditional conception of intention. We think that people don't go into crimes of acquisition knowing or like being very, very clear the intention is to screw over the poor or to screw over the rich. That is not what the necessary intention is. The necessary intention is to take the money for their own personal use, regardless of where it is from, right? We think that that's the intention. But the moment you peg it to the wealth and the circumstances of the individual victim, you change this conception of what the law is. And the law essentially becomes very disproportionately weighed in favor of one group or the other. We don't think they specify who this group is, but we're going to assume that one group is going to be privileged over the other because that's what the motion calls for, right? What does this then mean? This then means the law delves into a realm of inconsistency. And why is that potentially problematic? Because individuals then aren't capable of adjudicating for themselves what the potential sentencing of their crime is. And we think that that's a very powerful factor of the law, that the law exists in order to not just do retributive justice, but also things like deterrence. And if I know that, for example, if I traffic drugs, the crime for me is very clearly that I will be hanged, then at the end of the day, or like I will be like face capital punishment. At the end of the day, I'm very clear what this sentencing is. I'm more likely to uptake this idea of deterrence and be able to respond to the notion of deterrence because I know very clearly what the sentence is. However, on their side, they're going to leave it to chance and say that based on the wealth of the individual victim, you are going to leave the law open to interpretation based on what we think the context of the victim is. We think that this creates inconsistency in the law, and the product and the actual harm of that is that it removes the deterrence factor of the law, especially for acquisition crimes. And what else there is to that is that individuals, let's turn the targeting argument again on its head. We think that it's far more likely on their side that individuals would like to identify the context by which their victims exist in order to target them for either a lesser sentence if they know they are intentionally flouting the law by criminally acquiring certain things. We think that it's far more likely on their side that an individual is singled out for the context by which he or she lives in, the wealth that he or she has, in order to, like, as the perpetrator, receive a lesser crime. We think that that is what they open the law to. And we think that fundamentally, the law loses its power, and this is a great perversion of justice, not only because you are not proportional to what the law necessarily is, that we charge you on the basis of like doing the crime itself, that a murder is a murder, regardless of whether poor or rich, and at the end of the day, hurts the ability for the law to be a deterrence. Go over outside the house.
Thank the speaker for her speech. Berhati-hati. Keluar. No, we exit.
That's not so run.
Kote ayam,
Rabi goreng.
kote ayam roti goreng.
You don't eat that tonight.
Yes, no, let's go to Bobby. No, yeah.
Ladies and gentlemen, we would argue that at this point, opposition is not engaging in the actual debate, Mr. Speaker. Because I don't know, at some point, Valerie wanted to talk about the civil law, then she wanted to talk about criminal law, then she wanted to talk about punishing victims, and then she wanted to talk about punishing you. It was unclear what is the principal opposition of opposition in this debate. What did we tell you on our side of the house is that whilst there is some degree of certainty in the sort of punishments that we met out under the criminal justice system, that often there is a deprioritization in the way in which we engage in non-physical injury as well as crimes of acquisition, because there is a presumption that exists in status quo that just because you are of a wealthier or of a higher financial viability in status quo, that you don't get accorded as much dignity, or you get capped based on a societal good. Whereas we argue that the standard in which you utilize an objective of social and collective good isn't like analogous to the sort of investment as well as the sort of outcomes that is that individuals engage in when it comes to their property, Mr. Speaker. And that's why Mukriza's argument was very important in terms of at what point does criminal acquisition and wealth converge, Mr. Speaker. And we will argue that this sort of amorphous measurement that is utilized in status quo is insufficient, Mr. Speaker. Let's first analyze the distinction between a civil and criminal law and why we think that this does not fall within the case that Valerie wants to talk about. Because she argued in his speech that it is unfair to individuals because when you steal money from a poor person, the sort of financial return that comes back to that person is going to be proportionate to their wealth. That's not the debate, Mr. Speaker. We are talking about the ability to assess a criminal law and the sort of punishment that is given onto the individual independent of any sort of damages that goes back to the person. So the evaluation is also regarded to things like honor and dignity that is attached to the property rather than to the person's cumulative income, Mr. Speaker. But even if I accept that, right, I think that the thing that we have to analyze right now, secondly, is are we really punishing victims? No, thank you. The thing we will argue from government is that the dignity of victims, albeit you are rich or you are poor, should be viewed in isolation and not in comparative to where your income bracket is in society, Mr. Speaker. But what do we want on the outside of the house? The dignity that is attached to the property that you accumulated proportionate to your wealth, Mr. Speaker, and that's genuinely important. They then argue that your intent and your action should be the only way in which we measure or the way in which we assess how we punish crimes under the criminal justice system. We think that one, intent and action is already categorized to different actions or different crimes, Mr. Speaker. And that's why we think that it is always viewed relative to the victim, especially when it comes to a physical crime or an injury that is attached to the physicality of an individual, right? To what extent does a rape victim suffer injury when she is or he is assaulted, Mr. Speaker? But we think that often when you view crimes of acquisition, because there's so much attachment attached to how much wealth you have, often people argue that the rich don't really need this sort of honor and dignity redressed under the criminal justice system because, well, they always have wealth to fall back on. That if you're a middle income individual, you will still have wealth to fall back on, ladies and gentlemen. And we think that's problematic. And that's why we will argue that on proposition that you can utilize a reasonable man's test, no thank you, in assessing that you have to reasonably ascertain who is going to be the victim that you are going to perpetrate the crime of acquisition against, Mr. Speaker. Because if you're an individual who wants to commit fraud or criminal breach of trust or criminal misappropriation, you will have to assess that there is some substantial financial outcome that I'm willing to trade off when I'm engaging in this behavior. That's why we don't think people will attack or engage with the poorest of the poor, but we think it spreads out across the middle income onwards to the higher income individuals, Mr. Speaker. Thirdly, let's deconstruct the scale of harms particularly and why we think this acknowledges the fact that individuals did work particularly hard for their property. Mukesh told you in his speech, right, the ability for you to exert a particular amount of exercise and control over what sort of money you get and how you further extend your wealth is genuinely important as well. This debate isn't just about the person who invested a lot in shares and have a lot of money. It's also about the teacher or the nurse who invested a lot of money in in gold, for example, in order to have a return to go back to their retirement fund. And that's important. We think that at this point, the acknowledgement of the criminal justice system isn't just the propensity of harm at the point you are being injured right now, but in trying to restore you to the point of life before you were able to get that, Mr. Speaker. And we think that the parallel exists when it comes to crimes relating to physical injury as well, especially when you acknowledge that if a person, for example, is assaulted and battered to the point at which he's never able to materialize a likelihood or he's never able to work anymore, the proportionality of that punishment is extended to a greater degree because the state acknowledges the fact that your life past the point of that crime will never be the same or analogous to your life before that. And that's why we think that even if, right, you're going to talk about the poorest of the poor, we think at this point in status quo, there is no certainty to the sort of legal redress that that you want to talk about, because oftentimes the ability to prosecute a case is at the behest of the public prosecutor and contingent upon the viability of the argumentation. So crimes of acquisition is going to be a little bit more difficult to prove for individuals within the poverty or brackets of poverty, because you don't know how to assess how much money this person has lost. Rather, we will argue that there's a greater propensity of harm that is accrued by a person who's a lot richer. Before I move on, yes.
If you want to ask for compensation, you can still do that through a civil suit, which rich people very often win. Why do you want to institutionalize a policy in which rich people particularly get favored on your side?
Okay, the first thing that you have to acknowledge right now is that the motion says punishments for crimes of acquisition. The distinction between the criminal and civil law that we spoke about, Mr. Speaker, is that oftentimes when you're talking about civil suits, it isn't necessarily viewed as like a form of retributive punishment, rather than a negotiation and discussion between two groups of individuals. That's why it's labeled as damages rather than a punishment, Mr. Speaker. But secondly, let's recalibrate the way in which individuals view this, right? So even if we accept the paradigm that they want to operate on, which is the rich, right now we have to acknowledge, Mr. Speaker, that when you are talking about a breach of trust or misappropriation of fund, is that often society is often quick to judge the rich and say that they are going to be not altruistic, that are going to be malicious in nature in the way they engage in their policy and in the way in which they engage in their cases, Mr. Speaker. We think that the way opposition views injury is so myopic. It's like a tunnel vision, that you can only be injured insofar as you are not rich, that you can only be injured insofar as you're not like a trust fund baby, for example. We think that even in that regard, there is no it's not illegitimate for a person who's rich to want to claim a higher degree of financial redress or like legal redress at the point where someone takes a large sum of money from me, because the amount of effort and investment that's given onto that person is genuinely important, Mr. Speaker. There is a generalization that exists in opposition when they say that just because you are rich, you are unlikely to act or think for the best interest. We think that at the point at which a person is removed or the dignity of his property is tarnished, we think this is when the state has to provide that redress.
I thank the Speaker, Deputy Open.
So before I move on to my constructive material, we're looking at two issues in the debate, right? Two responses to the other side's case. Firstly, on how we should punish individuals, and secondly, do we achieve some sort of redress, and which side kind of does it better? So let's look at the first issue, right? How do we punish individuals? Okay, so the kind of arguments that came out from Prime Minister was that he first acknowledged that punishments are usually very arbitrary in nature, and then they had a problem with judges because they say that judges are very subjective in meting out the punishment. Okay, so our response is this on the idea of subjectivity. Like, number one, we think the judges will still exist anyway under their side, because at the end of the day, they'll still be around to kind of determine the kind of punishment that you have. But we think, secondly, and more importantly, the role of judges in pursuing crime and in pursuing justice, right, is to determine punishment based on the law in the way they best see fit. The greatest way to achieve equitable justice is to have a consistent foundation from which to apply the law from. What do they do on their side? We think that they shift the goalposts, right? Because they essentially give certain benefits to certain individuals over others. And we think the issue of subjectivity, if they really want to argue it, is far worse on their side. Why? Because on government side, arbitrarily, right, a rich person, for example, could possibly stand to gain more redress, right? Because the criminal, for example, took more from it. That's exactly how their policy works, right? Because they say the more money is taken away from you, the more you stand to gain, right? So this already takes down their characterization about application of justice, right? Because like it's very easy for these rich people, as Valerie already told you, to achieve some sort of redress, because we think the ability for poor people, for example, to achieve redress is far less. Secondly, they also told us that rich people deserve to be just as compensated because we base things on wealth creation and they work just as hard. Okay, so our response is this. In status quo, right now, like, we make sure that no matter how much you steal, right, the fact is that, like, what is important here is the fact that you stole, right? It's not that how much you steal or how much you didn't steal, but that you committed a crime, and therefore we place the law and we place a punishment on you. We don't subjectify this punishment, right, based on how much wealth you've lost or like how much you didn't lose, right? It's more about the application of the law itself, the fact that you stole, the fact that you paid damages and the fact that you received some sort of punishment. On government side, on their policy, right, a rich person would possibly have a better ability to achieve redress because they're able to spend more money on lawyers, they're able to gain more. We think that their side, what it does is amplifies the system to show how much more it is skewed towards one section of society. Then we brought to you the idea of like things such as like compensation, right? We told you that the ability for rich people to achieve redress in society is far greater than the ability for a poor person to do so. What was the response? The response was very dismissive, right? They told it, no, it's an issue of dignity, right? Okay, so let's deal with this idea of dignity, which then moves on to the second issue that I have in this debate. So Jay and Mukris told you that this debate is about dignity of individuals that is lost. Okay, sure. But we think that issue, if you really want to make it about dignity, we think it does. Dignity is addressed far better on our side when we require laws to be consistent in their application. On their side, right, some people's dignity is seen as more important than others, right? There's some sort of like value placed on individuals' dignity. We think that dignity is relative to an individual, and a poor person has every right to feel like loss of dignity when $2,000, for example, is stolen from him, compared to a rich person when who feels just as aggrieved when $10,000 is stolen from him, right? We don't think the issue of the issue of like dignity can necessarily be like quantified into how much more you lost as an individual. So it's very difficult for them to claim that we can use dignity as a metric here, because it's extremely hard for courts and judges to judge the level of dignity, because we didn't really feel that they explained the mechanisms either. Lastly, right, they told us that the dignity had to be related to the property rather than the person. So we told you that this motion, right, specifically asks for distinction to be on basis of wealth. But let's then say that their problem is with wealth creation, right? We think we are willing to accept and argue on our side that rich people work just as hard to accumulate wealth compared to a middle class or poor person. We don't deny that characterization, right? We think that is extremely true. We don't contest that. We think instead, right, that the punishment should not matter and should not be principally, or I'll take in a moment, should not be principally about your wealth, but we think we can't use wealth as a metric because it's far arbitrary. And the reason why it's arbitrary is because of a few things, right? Before that, yes.
If you're going to say that the law needs to operate on an equitable basis independent of your economic status, would you support a world in which we remove poverty as a mitigating factor in crimes of acquisition?
No, okay, we think that poverty is like ultimately regrettable, right? But we think like the law doesn't make distinctions for like certain situations. I explained that further in my arguments, right? So we think through their side, the application of a punishment, right, has to be put through a further arbitrary hoop, right? Because you have to put through the ability of judging a person's dignity, the amount of dignity that a person has lost when you ascribe punishments for it. So we don't really think they solve anything on their side. So let me move on to constructive material, right? So today I'll be talking to you about how we should change the ability for laws and justices to continue to function with some sort of equality. We think that laws and justices are powerful and are efficient because it is an equalizer, right? That is free from bias and is applied equally. If a poor person and a rich person both commit a crime, you can't say that a rich person necessarily deserves a harsher sentence because he was privileged, right? Because we think some people have different intents for committing crimes. Because, but at the end of the day, we punish them all the same, right? We don't make exceptions based on like how much you really wanted to steal a particular item from poor person's perspective compared to vis-a-vis a rich person. So why is this important, right? We think because we think this sends a narrative that your punishment is not dependent on how much you have to gain or lose, right? But whether you choose to commit the crime in the first place. Similarly, we think justice systems aims to be principally consistent in the application of punishment. We think your ability to be aggrieved, right, and your ability to gain some sort of justice from as a victim, right, should not be dependent on certain specific or arbitrary measures. We think that everyone has a right to feel equally aggrieved, right? We think that a rich person, poor person, it doesn't matter. You are still a victim at the end of the day, and we recognize those things. But we don't place the ability for you to be seen as a victim, and we don't place an arbitrary value of someone feeling far more aggrieved than another person just because he has more to gain or he has less to gain. The fact is that a crime was committed on you at the end of the day, and you are a victim. Simple as that. We don't make distinctions on how much you felt aggrieved, but we rather try to make sure that the law is made as best equitable as possible. So what are the outcomes of this? We think that's incredibly important for laws to be equally consistent. Because at the end of the day, we think that judges, when making sentences and punishing people, right, need some sort of foundation on which to rely on which to operate on. if you constantly change the metric by which they apply those laws, we think that it makes the justice system extremely pervasive, right? Because then it bleeds itself into creating precedents for issuing more arbitrary laws and more arbitrary regulations to be made on the principle of possibly being more redressable. Because we don't think that happens. We think equitable justice can only be done when the law is made consistent, and we think we solve this better on our side.
The opposition, Deputy Leader. Yeah.
Mr. Speaker, two key aspects in this debate that needs to be evaluated. Firstly, which side better provides justice to victims? Second of all, which side better represents the severity of the crime via the criminal justice system? Firstly, which side better provides justice to victims? Firstly, let's just really clarify the criminal justice system for a little bit, right? The operation of the law in regards to the criminal justice system is that, and this is of course in instances where it's a criminal offense, mind you, the victims will definitely get back what is lost from them. And beyond that, the role of the criminal justice system is not necessarily to provide redress to the victims, but it's purely on assessing retribution and also assessing the punitive measures that the state will take upon the perpetrator, but not necessarily have any correlation with the victim in terms of like how much will be given to the victims, right? However, given this, ladies and gentlemen, the goal of the criminal justice system is to not assess the injury that was taken by the victim in isolation. The assess of injury has to also be considerate of the victims as well as the circumstances surrounding the offense that is also related to the victims themselves. Given this, the law heavily relies on the law of equity. What this means is that the practice of law is not necessarily strictly an objective practice. It is strictly an equitable one whereby they practice by the assessment of different situations and different circumstances that greatly differs case by case. Given this, ladies and gentlemen, what the court necessarily assess is the position of the victims. What we have to look and observe here, ladies and gentlemen, is that the positions of the victims, especially in cases of acquisition, differs because of the wealth of that victim. This means that the kind of loss that is represented by a person who is of a middle income and the kind of loss that is represented by those who is of a higher income is completely different. And the reason for this, ladies and gentlemen, is not because we are looking at the victims in isolation, but we also have to look at the value of that wealth and what is the probability of positions that that wealth can attach onto these victims. What I mean by this is, what a rich person can do with ringgit 1 million would greatly differ and would be of a higher magnitude than what a single person can do with 50 ringgit that was taken away from him. This means then, ladies and gentlemen, the outcomes of these individuals greatly differs, but more importantly, the lifestyle that these individuals practice also greatly differs as well. So this means you can't assess both of these victims in uniformity, and also we have to assess the kind of lifestyles that is practiced and how far is it derailed from the lifestyles of these individuals, which makes it more equitable. This then means it's not that we won't punish anyone who steals 50 ringgit from a single person. Of course we would. But the problem here is that we have to also assess what source of dignity is attached onto these individuals because they lost 1 million ringgit as a result of their position as a rich person running a rich company, because they could possibly do a lot of things and could gain a lot of things with that 1 million ringgit investment, as opposed to a person who can gain certain things with the 50 ringgit that they have with the position that they are in. Given this, ladies and gentlemen, let's respond to the opposition. It's not arbitrary because, firstly, ladies and gentlemen, we believe to a very large extent, courts and judges with that conventional wisdom have always objectively assessed the situations of these individuals based on the law of equity. Like, for example, it can be argued that in a civil case, for example, it's hard to quantify damages to a general damage, which is based on pain and suffering and things you can't necessarily quantify. Judges have the ability to quantify this, and more often than not, it can be argued to be the authority as to it being fair. This means that they also assess the quality of damages on a case-to-case basis based on the pain and suffering of the parties, the same way that the court can do in evaluating the circumstances of the wealth of these individuals and how much they have lost because of the wealth, because of the position that these individuals are in, and the fact that there is a difference in the derailment of positions when a middle-class person were to lose a certain amount of money, and if a rich person were to lose a certain amount of money as well. In comparative to what this site provides, ladies and gentlemen, no thank you, is that the application is looking at crimes in isolation of these circumstances. This means that just because you commit a crime of a criminal breach of trust, it doesn't matter as to the position of the victims as well as the wealth of these victims. They are both quantified with a single amount of punishment and single amount of punitive value. This means, ladies and gentlemen, they do not put into consideration the position of these individuals and the position of these victims when assessing punishments and when assessing what is fair for the victims, ladies and gentlemen. Also considering that the dignity is not necessarily relative to the individuals, but it is also relative to the property that is taken from them and the role this property is playing to a person who is either of a higher income or to a person who is of a lower income. The role that the amount of money can be used by a person who runs an investment bank, and also the role that 50 ringgit can be played by a person who is solely a teacher. These are different circumstances, and the court must provide preferential treatment to the cases of these two instances. Therefore, ladies and gentlemen, it is more likely it is fairer under this side of the house in regard to justice to victims. Second question, which side better represents the severity of the crime? So this primarily was raised by the opposition. They say that the quality of punishments that we attach onto a person and to an offender should be solely on the intent of that crime and the solely commission and intent of committing a certain crime. That means you commit criminal breach of trust, you should be punished as such, and the end of story is there. We say, ladies and gentlemen, that this is extremely too objective and stringent. We say that the reasonable man's test has always been applied by courts when they assess the fact that intent of committing a certain crime is always quantified with who you are stealing from, as well as quantified by the circumstances around that theft or also that robbery. The reason for this, ladies and gentlemen, with the reasonable man's test, if I were to steal from an investment bank, I know precisely the amount of money that I could have stolen from this bank, as opposed to knowing who I'm stealing from, who is only a person who is making 50 ringgit, and knowing how little I can steal from that person. This means, ladies and gentlemen, intention is not in isolation of the crime, but intention is also attached and quantified by the amount that you have stolen, but also the background of the person that you are stealing from, ladies and gentlemen. This side of the house is a lot fairer, which is government.
Thanks. Come good. Just move. You can take mine. You can take mine.
Okay.
What I don't get about prop case is how they conveniently managed to shift their stance through three different speakers. So what came out in Mukris's speech was this idea that, oh, rich people are often ignored in the criminal justice system, and that's why they don't get some sort of redress when you are assessing the crimes that are committed against them. So basically, like, oh, rich people get fucked over by the legal system. That completely changed by the time Izzat's speech came around, when he wanted to create a system which is proportional to how much wealth is stolen from you. We think that that doesn't sit in line with this idea that you want some sort of equitable punishment to be provided to both rich people and poor people that was coming down the line from Jay and Mukris earlier on. But leaving aside all that, some of the premises in their case are things that I assume would never be said in a debate to begin with. In the legal system, rich people are screwed over is something that I never thought would be the basic premise along which a prop side argues. Let's set aside the fact that what they actually had to debate in this is the complete opposite of that poor people are often screwed over. It still remains possible for rich people to gain compensation through filing civil lawsuits after the criminal proceedings are done, which means that the whole idea that rich people's dignity isn't recognized can be mitigated by rich people gaining back a large part of the amount that they lost by filing a civil lawsuit as well. So let's clarify some of the problems that are extremely vague in prop case then. This first idea that people think rich people are rich and the legal system, like rich people are like rich and like there's no reason to care about them because they're rich and like they have everything that they need in the world. I cannot stress on how counterintuitive this is, given that poor people who often hurt the rich don't have a history of getting off really lightly, especially when you look at all the cases of poor people stealing from rich people that go into like district courts, and district attorneys fight even harder in such cases against making sure that that poor person gets prosecuted. This is very clear when you look at all the cases of racial divides in prosecutions based on things like theft as well, where clearly the people from lower income brackets are going screwed over a lot more when it comes to cases like theft. So I don't understand where this argument is coming from. But secondly, prop says that the people who steal from the rich people don't get punished. This makes it this basically makes their case completely ridiculous, because that ultimately means that they're trying to argue for people getting punished as a metric that they want, as opposed to what they really need to argue, which is some sort of like metric through which they assess like some sort of proportional punishment based on how rich the victim is. So based on what they actually need to argue, what are the clashes in this debate? What is the best metric then by which we determine a sentence? So Val started off by this idea that the determination of guilt and punishment in the status quo is done by assessing mens rea and actus reus through a judge. What does that mean? This means that a judge gets to decide what is an appropriate punishment for a crime based on assessing situations like how much criminal intent was attached to that crime and basically the action itself and how much harm dignity had then. But taking prop at their best case, they wanted to allow for rich people to be accorded the same dignity as poor people by allowing for equal sentencing like by the end of their case, which is extremely strange, because that ultimately means that they ran away from the entire motion, which suggested that they wanted some sort of greater amount of stress accorded when there was a rich person being stolen from more in the end, because then we don't see like why their measure is any less arbitrary than a judge making a decision, especially because the arbitrariness of their decision comes from the fact that you're institutionalizing a law which says that there's a distinction between rich people and poor people that wasn't really established on their side in any case. But then they asked about mitigating factors and where they come into the judgment in our case as well. Firstly, we said that this reduces mens rea, which is why mitigating factors are quite objective in the way that they come to the decision fact-making calculus of a judge. We think that prop wanted to reduce to the extent to which judges get to have a say in these cases in any case by institutionalizing a law which says that you have to sentence in this particular way by making people who by making people who steal from the rich more criminally liable and give them a larger sentence in the end. We think that that is extremely arbitrary as well. Before I move on, okay, sir.
Yes or no? A person who is of a middle income and a person who is of a higher income suffers property loss differently irrespective to the amount that was taken.
Firstly, this is not the case that was coming down from Mukris and Jay. It was completely different because they wanted to say that it's the same kind of damage to dignity to both people, which is extremely problematic. But we do agree that the damage to dignity based on the property that's stolen from you is the same, regardless of whether or not you're a rich person or a poor person. That property might mean the exact amount, like the exact same amount to you, which is why we have criminal sentencing and the determination of guilt based on judges assessing whether or not you committed a crime that objectively harms each person in a similar way. We think that it harms people in a similar way, especially because the amount of property that's stolen from you is usually given the same amount of worth by you as an individual as well. We think that each individual who loses their own property loses something that they are attached to, and that is a good reason for them to consider that this is an unfair metric as well. But secondly, who ensures that justice is the most fair in the end? We proposed on our side a system like a status quo where you have a couple of things that ensure that we have a fair trial for each of the perpetrators of a crime and a fair system that will ensure for like both retribution and compensation. How exactly did Prop try to counter this? What they want, like, firstly, this is extremely unclear, but secondly, but what came down from the end of their speech, from the end of Izzat's speech, was that they wanted, ultimately that rich people get some sort of preference within the legal system over poor people, especially because they lose more, like in some sort of objective metric that's money in the end. We think that that isn't really the metric that the legal system should be operating upon in creating a more fair system in the end. Why is this so? We think that the reason why we consider crimes proportional, like based on whether or not, regardless of who the victim was on which it was committed, was because it was specifically the same kind of it had the same kind of mens rea and actus reus attached to it. We think that that's why we consider the assault of a poor person or a rich person the exact same thing. That even though the poor person might face more damage because he has to pay a larger portion of his income to gain any sort of medical treatment for the damages that he faced, we think that that assault is still considered the same regardless of whom it was committed on, especially because they had the same intention behind those actions to begin with. We think that in terms of fairness, then it's necessary to assess who had the most intent who had the intent to commit the crime, and whether or not a person's dignity was damaged, period, as opposed to like to what extent some more money was stolen from them, which is extremely arbitrary. For all these reasons, we oppose.
Thank Opposition Whip.
So in the criminal justice system, we don't care if you are the son of a rich man or a poor man. If you die because of or if you get killed, murder, we still charge the murderer the same way, don't we? We think the idea here today is that they fundamentally try to conflate ideas of dignity, ideas of wealth, and how the law should work, without responding to our arguments in and of themselves. The inconsistency is probably a bad thing, which we probably told you throughout all three speakers, right? For the fundamental basis, their case only came clear in Izzat's speech. We would like to respond with this. Fundamentally, if they wanted to protect the, say, teachers and the nurses, right? This contradicts with Izzat's principles, which were to say that we should prioritize or we should give preferential treatment based on the dignity that your property accords you. We think that to the very extent of the application of that principle, which you can say an investment banker who needs a lot of more money to make more wealth, right? Probably accords more dignity to his money. They don't help the teacher and the nurse. The preferential treatment is given to the investment banker because it means more to him. That's how they decided to conflate dignity and wealth, right? But we told you, as opposition to that stance, that dignity means very different things to very different people. And we were likely to, we would rather say that perhaps, yeah, sure, the $500 means the same thing to the middle income and the high income person. Because at the end of the day, we would not allow for subjective interpretation of law to decide for some individuals what's dignity and what's not. We think that at the end of the day, their side was the one that subjected the law to more inconsistencies. So what's fair, what's dignity? Biggest question, right? We told you on our side, this was mens rea, actus reus, that judges are perfectly capable of doing this in current status quo. Recognizing that they wanted to prove to us that there was some kind of inconsistency in the way we applied law in Mukesa's speech, in the first minute of his speech. What happens on their side is that they allow judges to even greater exacerbate these harms. Why? Because as we told you, the metric of what's considered as your dignified possession versus what's not your dignified possession is not judged by the person themselves, and they don't get to declare that this is what this really mattered a lot to me. It's judged by the judges, right? And fundamentally, they don't remove the same problems of inconsistency that we try to tell them would exist on their side as well. No response. We told you at the end of the day, when you conflate the ideas of dignity and the ideas of wealth, you leave the law to subjectively decide what means something to an individual. We told you that there's an inherent harm in inconsistency in and of itself, that it's a problem because you can't have the same deterrence effect that the law ought to have. We think that these are all things that they didn't want to respond to. Then what would they like to say then? That this wealth should be a metric by which we decide judgments in Izzat's speech, which he said like the law currently doesn't cater for, say, the how you would have better lived your life if you had that kind of property with you. Here's where we would like to also argue that judges can't access the counterfactual of what you would do with your life in the future. That nobody can reasonably access that your money would definitely produce these outcomes, definitely go to a place where you will make a lot more money from it. We can make reasonable assumptions, but at the end of the day, since nobody can access that kind of counterfactual, why would you subject the law, which exists to present penalties to individuals, exact retributive justice, and it means a lot to individuals when you decide what the worth of their sentencing is, to that kind of subjectivity based on what we think the counterfactual of your future might have and could have been. At the point in time that we cannot executively say that, say, the rich boy will spend his $500 on investments versus just sex, drugs, and whatever, we think that at the end of the day, we cannot leave judges to decide for the very fact that we told you this is not how the law ought to work. That if you want a fair and equitable justice system, the way you do it is by acting on intention. Intention meaning mens rea, meaning actus rea. We charge you the same way, regardless of who your victim is in a murder. The same should apply to wealth acquisition. Because as we assumed, we cannot say for sure that an individual feels the same way about property, regardless of income status.
Yeah.
But we can say that despite this, we would like to say that your property was stolen from you, your property was taken, and we should treat it as such. At the end of the day, that your property was taken, and therefore we should charge you on the basis that the property was taken, and the value of the property becomes the entire point of the case and the entire point of the law. Given that they were very, very dismissive in refuting our arguments and very unclear from their side of the house what kind of stance they would like to take and what kind of person they would like to help on their side of the house, they had no angles, or no clear angles rather, go with our side of the house.
Yeah. I thank the opposition by these debates.
I'm offended that they say we didn't really stand together and say anything substantial in this debate. It's not really our fault if you weren't really paying attention to our first speaker's speech and stumbled along in your opposition case, Mr. Speaker. Because we told you in our case that there is a value in acknowledging the convergence between your wealth and the outcomes of a crime of acquisition attached to the dignity of your property, ladies and gentlemen. And we told you from the get-go that the ability for courts and society to often deprioritize individuals on the basis that they may have accumulated a higher aggregate wealth in comparison to individuals who are poor is an unfair presupposition just because you're going to argue that there are such standards as actus reus and mens rea. We don't think you view or you utilize these standards in isolation in acknowledging the amount of investment that an individual may have made in accruing that property, ladies and gentlemen. That's why on our side, we're never a proponent between an absolute binary between the absolute rich and the absolute poor, but acknowledging that there is a spectrum of individuals that may be harmed in crimes of acquisition, ladies and gentlemen. So let's get the first issue. Let's evaluate that component of wealth, because we told you that though individuals may come into wealth in many different ways, the process of accumulation, maintenance, and extension of that wealth is also an important consideration in this debate. What did we say to show that the aggregate harm is a lot higher at the point at which your accumulative wealth is higher, Mr. Speaker? That the likelihood of you receiving harm as an individual when it comes to crime of acquisition is potentially a lot higher, Mr. Speaker. And this was the application of reasonable man test that proposition argued in this debate, that often when you are making a trade-off as a perpetrator of crime, that when you want to harm another person via things like fraud or theft or criminal misappropriation of funds, is that you make a reasonable assessment to the degree of harm I am about to inflict and how much substantial trade-off can I make in return to myself. So for example, I can reasonably guess how much money Mitra may have in his wallet, and I definitely know how much money Mukris has in his wallet, and I'm definitely going to attack Mitra rather than Mukris, Mr. Speaker. What was the response? That there's an institutionalized discrimination attached to two things. One, that the rich never really get screwed over in the criminal justice system, Mr. Speaker. I told you this, right? That often the debate has to operate on a spectrum and acknowledge that it's not just about the absolute rich. But we also think, Mr. Speaker, that oftentimes because there's a deprioritization, exactly because of the rhetoric that they provided in this debate. Because the sort of argumentation that was used by opposition, even if you don't get redressed in criminal law, at least you can still go to civil court, right? You can still get or fine people. We think that this shows that the injury that impacts a person who's more well off comparatively to a person who's less well off is essentially shrugged off in the criminal justice system because there's an acknowledgement that you can often get redressed elsewhere, Mr. Speaker. And we think that the accruing of that property is often attached to dignity as well. And that's why we don't think that dignity needs to be and has to be a direct comparison between a poor person and a rich person, but has to view independent of your financial status and look at the process in which you receive that, Mr. Speaker. And that's why we think that even though they want wanted to argue why the law needs to operate on an equitable access, we don't think they were able to disprove things like mitigating factor and showing why the poor can deserve more than the rich. We don't know why the converse doesn't apply in this debate. So we think when you are talking about mens rea and actus reus, we think it has to be viewed relative to the victim, Mr. Speaker. So much hype is given to things like physical injury, but not enough to non-physical financial injury. So things like rape and assault don't account for wealth, but it accounts for the person before and after the point of injury is inflicted onto that person. It is the same principle here, Mr. Speaker. If you remove a large sum from an individual who has accrued that wealth, we think that it's problematic for that person as well. Secondly, is it really inconsistent? We told you that there is a bare minimum in which the state utilizes, but the point at which that you can't be extremely consistent or objective because every single case is different. Because we think that at the point at which acts may occur similarly, outcomes, harms to dignity don't occur similarly to individuals as well. And that's why justice always have to be different and individualized to that cases, Mr. Speaker. And we think that this is very important because acknowledging things like mens rea and actus reus is insufficient without acknowledging the victims and the propensity of that harm that is likely to occur to that individual.
Our time, all speakers, teachers, control, take your booties and leave.
No, I don't
see our booties.
It's always so funny. It's always screaming. Oh yeah, GG.